Good morning, Mr. Gecken, Mr. West.
Good morning, Your Honor.
Good morning. And so I'll note for the record, before we begin, that I have received a significant volume of material, all of which I have reviewed, including the supplemental information provided by Mr. West to support his recall petition. And what I would like to do today is to, because Mr. West is the proponent of the petition, to have him go first and last as if this were a motion that he is supporting. And I will let both sides know again that I have reviewed carefully everything that has been submitted, so I don't need to hear a recitation of what has been written and provided to the court, but rather just to answer my questions, obviously, and to hit the high points, so to speak. So with that being said, Mr. West, you may go first.
Thank you very much, Your Honor.
And I would like you to address first, and this is kind of backwards in terms of what the numbering is from the Attorney General's work on what it would look like. The allegedly improper support for the initiative last year. What evidence are you basing your claim that he violated the law on?
Very good, Your Honor. The original charges explicitly claimed that the governor, by improperly using state resources and the authority of his office to campaign for an environmental initiative, the Honorable Jay Inslee knowingly committed misfeasance and or malfeasance that violated the terms of the oath of office. That's page 4, lines 4 through 5 and 8 through 11 of the original charges. This claim is supplemented by the communications of the governor's publicly funded policy staff, such as Mr. Baldwin and Ms. McCoy of May 1st and September 28th, respectively, regarding the promotion of I-1631, and the Atlantic article quoting respondents saying that he will do everything he can to promote the initiative, along with a picture of our governor collecting signatures for I-1631, while his publicly funded State Patrol security officer, Mr.
Wait, I'm sorry, could you slow down a little bit? Sorry.
While his publicly funded security officer, State Patrol security officer, Mr. Tipton, stands in the background in black sunglasses. This demonstrates the use of the influence and authority of the office of governor for improper purposes in a manner orders of magnitude greater than that found to support a recall in the case of former Mayor West. In addition, as to personal knowledge, the petitioner and virtually everyone in the state with a television set has personal knowledge of the governor using the influence of his office to campaign for I-1631.
But he's allowed to speak about matters as long as he's not using public resources to do so, right?
He's allowed to make statements, but I don't think that allows him to urge the voters to vote for an initiative.
So what kind of statements would he use if he supported something other than urging people to vote for it?
I think what the law intends is neutral statements concerning the support of the governor of the office for the initiative, and I think this was transcended by appearing in media events and campaign commercials.
And what law would you cite to support that he can't make any statement supporting it, even if he's not using his public resources to do so?
I would cite the campaigning laws. Okay, there's a difference between supporting an initiative and actively campaigning on behalf of an initiative. I think that's where in the ordinary course of their office, a public official can express support for an initiative, but I think this is transcended when they actively campaign for an initiative, such as collecting signatures, appearing on television spots, actively soliciting voter signatures for and using the influence of the office for that. I think transcends the boundaries of the ordinary and customary use of an office for speaking on a ballot proposal.
So turning now to the numbers 3 and 4 as the ballots and notices from the Attorney General's office has enumerated them. This is concerning the failure, in essence, to use executive powers and/or to to declare an emergency regarding homelessness. This is a discretionary act, and under recall case law, one needs to have a prima facie case that is a manifest abuse of discretion in these circumstances. So what do you believe here demonstrates that that standard has been made on a prima facie level?
First off, Your Honor, I proposed a corrected ballot synopsis, and I have a copy of that here.
You can hand it to the clerk.
If I may approach. But I think more accurately sets forth the claims. There are also claims in the original charges of failing to address a known and worsening health and safety environmental emergency at the seat of government in Olympia throughout the state. Page 4, lines 6 through 7. Deliberate refusal to perform his duty to ensure the environmental nuisance and criminal laws. The environmental nuisance and criminal laws of the state of Washington were faithfully executed throughout the state of Washington and within and by the city of Olympia. Page 3, lines 2 through 3. Failing to act to ensure the integrity and continuity of government of the state of Washington in the face of this worsening known public health and safety emergency at the seat of government. And that he also failed to act in regard to the emergencies that were declared to exist by various other government entities within the state. These were supplemented by the letter requesting the governor to declare a state of emergency for the city of Bellingham, the formal declarations of emergency from Seattle, Tacoma, and Olympia, the letter requesting that the governor declare an emergency from no less than 18 cities across the state. These records, in addition to the declarations, pleadings, and transcript from Leahy versus City of Olympia, document an open, notorious, and undeniable emergency exists through the state, and particularly here in the seat of state government, where those of us who actually reside here have to see it and deal with it every day. These records demonstrate beyond a shadow of a doubt that local jurisdictions are simply unable, incapable, or unwilling to enforce the nuisance, environmental, and public health and sanitation laws in the face of this overwhelming tide of unhoused individuals in the urban, suburban, and rural areas of our state, especially without the necessary help from our governor, which many of them have requested to no avail. Now this gets to the central legal issue of the case, which is that the governor, like the president, exercises unique powers unlike any other office in our government. And these are not in the line of the discretionary legislative actions of a port commissioner or a mayor. As the Governor Riley, Martinez cases, and long line of authority stretching back through the centuries demonstrates, the powers of a governor are different in scope, or as different in scope from those of a mayor or a port commissioner as those of a king from a bailiff or a sea captain from a boatswain. The unique duty of a chief executive officer under our Constitution and laws to act to preserve the peace and integrity of government and to ensure the faithful execution of laws is not a discretionary function like that of a mayor or a port commissioner, but a solemn and binding duty with roots stretching back through the centuries to before the dawn of our Anglo-American system of republican government. It is correct that a municipal officer, in the exercise of his statutory legislative discretion to hire an employee or approve of a budget item, is entitled to wide latitude, to which recall proceedings are often inapplicable. But such precedent has, and should properly have, very little weight in the determination of the very different constitutional prerogatives of a chief executive officer solemnly charged with executing the faithful, with ensuring the faithful execution of the laws. In this case, there's an undisputed emergency which has endangered the health, safety, continuity of government, and quality of the environment of the people of the state, and which has resulted in local and widespread inability, incapacity, and or unwillingness by local jurisdictions to enforce the laws of nuisance, environmental protection, or basic sanitation. For the respondent to seriously maintain, in the face of requests from cities representing the majority of the population of this state for specific action, that it is not at least manifestly unreasonable and an abuse of discretion for the governor not to declare an emergency and to fail to act to ensure the faithful execution of laws is not only unconscionable, it is a posture that, if judicially sanctioned, will ensure that the citizens of this city and this state will continue to suffer from an intolerable, long, or perpetual state of emergency, of undeclared regional emergency. As our first president, George Washington, observed, "It is my duty to see the laws executed. To permit them to be trampled upon with impunity would be repugnant to that duty." Similarly, in Prince versus United States, the Supreme Court explained unequivocally how the president executes the law. The Constitution does not leave to speculation who is to administer the laws enacted by Congress. The president, it says, shall take care that the laws be faithfully executed. This court should rule in accord with the ruling of the Supreme Court in West and the venerable authority cited in the briefs, and approve the ballot synopsis in this regard.
So turning, again, using the Attorney General's ballot synopsis numbering, to number 2, the residence issue. Are you still maintaining that? It was unclear from your initial response to the governor's briefing whether or not you were conceding that this might have been a hyper-technical, unsupported element of your charges.
The residence issue, Your Honor, is not the strongest claim, and I openly admit that I have no personal knowledge as to where the governor is at each point of the date. That one, I think, could properly be removed, but I would point out that the intent of the requirement in the Constitution, Article 3, Section 24, that the governor reside in the state, indicates that the governor have at least that degree of relationship to the community, that he's in touch with what's going on, and that he accurately represents the citizens of the state. I think there's arguably a case has been made that that level of continuity has not been seen, especially in light of the lateraling of the governor's authority to the Secretary of State on 10 separate occasions.
And that's the next and final point for us. So let's turn to that one. And I want to make sure I understand. It's not that well, I guess there's 2 elements. One, he's gone so much that he's created a vacancy in the office. There's a second element that I was trying to follow, which is that you're claiming that he has improperly, when the lieutenant governor is also gone, automatically defaulted to Secretary of State Wyman. Is that correct?
Yes, Your Honor.
Okay. And so at what point does someone leave the state so often that it creates a vacancy in the office?
Well, that's a good question. But the original charge, unlike the charges prepared by the Attorney General, I've asked the court to review the proposed corrected ballot synopsis that I provided. The original charge contained the statement, "By his frequent absences and failure to properly coordinate with Lieutenant Governor, vacancies in both offices were created, requiring the Secretary of State to assume the duties of governor in a manner at variance with the sound and orderly governance of the state of Washington." This was supplemented by 11 copies of correspondence from the governor documenting the routine practice of deliberately violating the express terms of statute by requesting the Secretary of State to, in essence, pinch hit for the lieutenant government so that both the governor and the lieutenant governor could evade their duties under the law to exercise the powers of the governor as required by the express terms of statute. If the documented deliberate violation of the statutory terms of law expressed in the imperative directive shall is not at least misfeasance and a failure to execute the laws failure to ensure the laws are faithfully executed, I can't imagine what would be. State versus Bartholomew and State versus Kroll both stand for the proposition that the term shall, as it's used in the statute requiring the lieutenant governor to act when the governor is absent, that this is a mandatory requirement. This mandatory requirement of statute was deliberately flaunted to the detriment of the continuity of sound government in the state of Washington.
So I have no more questions, but you may use some additional time if you have additional points you would like to make.
Yes, Your Honor. I'd like to point out that the respondent asserts a number of hyper-technical arguments as to the recall process, but these are simply not consistent with the memorandum filed by the Attorney General or the ruling of the Supreme Court in the West recall case, cited extensively in the reply, which clearly allows supplementation of the recall charges and correction of the ballot synopsis by the court in the sound exercise of its discretion, and hold that the mere technical defects are not sufficient to obstruct a recall. The amicus brief of the Attorney General and pages 1 through 3 of petitioner's reply brief set forth the legal standard that actually applies to this case, and it is not that argued by the respondent. That's all I have, Your Honor. Thank you.
Thank you, Mr. West. Mr. Gack.
Good morning, Your Honor.
Good morning. So the only question, I'll allow you to make your presentation, but the one question I have for you is if you, because this was kind of a shifting target, I think, in the briefing regarding what the first charge actually is. And so if you wouldn't mind explaining how we get from the governor to the Secretary of State when both the governor and the lieutenant governor are absent.
The governor contacts the Secretary of State due to the order of succession in the Constitution. And when the lieutenant governor is unavailable, then the governor is always contacting the Secretary of State to ensure continuity of government. And that really then helps reveal why there's no violation of RCW 4306040. That statute facilitates the coordination with the lieutenant governor. The shall in that statute refers to the lieutenant governor's duties, but it does not restrain the governor from leaving the state. And so one of the questions Your Honor asked was, well, how many times is too many? And that really reveals the lack of legal sufficiency here, is there's no test that shows the governor can't leave the state a certain number of times, or can't invoke this statute a certain number of times, or can't even work outside the statute because the statute doesn't purport to restrain the governor from leaving the state if by the lieutenant governor's serendipitous unavailability. And in any event, even if all that, even if there was merit to this statute that it was intended to restrain the governor, this is a situation where the case law about the governor's intent to violate the law comes right into play. There's no intent to violate RCW 4306040. Clearly the governor is intending to comply with the order of succession and the plan of government there. So that would be legally insufficient on those bases. Probably the best way to go next is into the, in the order they were put in the ballot synopsis by the state, by the Attorney General's office, and that is the residency on Bainbridge allegation and the office in D.C. There's been no argument about the office in D.C., and I think our brief indicated that having the secondary offices is not a violation of Article 3 to Section 24. And hearing no argument to the contrary, that one should be determined legally insufficient. The allegations about spending time on Bainbridge Island are also legally insufficient and factually insufficient for the reasons that Mr. West, I think, forthrightly conceded this morning. He doesn't have sufficient knowledge to know the governor isn't really residing at the governor's mansion. Now this turns to the question of what does reside mean for purposes of the Constitution, and this court doesn't have to find exactly what that answer is here because there's no sufficient evidence here to show that the governor is not residing there. There's just some evidence that he spent some time on Bainbridge. And again, that comes back to another question of law, which is there's no evidence that the governor, or no allegation that the governor is intending to violate the constitutional residency minimum that's called out in Article 3, Section 24. So that should be determined to be factually and legally insufficient. The third and fourth charges and the discussion of the homelessness situation in Olympia and in other cities, and the requests by various local governments that the governor invoke emergency powers, all these should be rejected as legally insufficient because of the basic premise that a legally sufficient charge of malfeasance, misfeasance, and violation of oath of office depends upon a legal standard that the governor would be violating. And here there is no legal standard. We're dealing with a realm of intense executive discretion when to declare an emergency or not. And we've in fact been talking about our president declaring an emergency in the news lately, and one can very quickly see that that's a discretionary sort of decision that gets involved in the executive. It's certainly...
But there's some threshold at which, I mean, the case law does allow this release valve, let's say, for some circumstances where there's a manifest abuse of discretion, which is somewhat unclear to me, I'll admit, from reading those authorities, and also seems inconsistent with relying on discretion as an absolute defense. Wouldn't that be fair?
I think that is fair, but I think then a manifest abuse of discretion would be something where it would be so arbitrary and capricious that reasonable minds could not differ.
So if half the state is in a forest fire and nothing is declared and everyone knows that that's something you do, is that what you're imagining?
Exactly, and it would be a situation and where Mr. West has not come forward with sufficient law as to exactly what the governor's declaration of emergency was supposed to accomplish. Perhaps it's symbolic, perhaps it accomplishes something legal, but in the absence of knowing what it was supposed to do, we can't judge that it was a manifest abuse of discretion. And we've cited the cases with regard to that, and the ones that I would point the court to are in our brief, but there's also a case called Bolt, in re the recall of Bolt. It may be cited in our brief also, but it discusses this abuse of discretion standard, and it's a good case to read in terms of looking at allegations for sufficiency of recall. Justice Owens there goes through about 10 different scenarios that were deemed legally and or factually insufficient. And the failure to declare an emergency would be very similar to some of the discretionary duties that were deemed legally insufficient in that case. So getting back to the basic test of discretion, there's no legal standard that Mr. West has shown that compels the governor to declare an emergency. Well, it's a good political argument. That's where it belongs. It belongs in the realm of politics, not in the realm of a for-cause recall. And finally, with regards to the fifth charge in the Attorney General's summary, there is a threshold question that we have to look at the original charges that Mr. West filed. Those are attached to the petition. And those charges did not bring up 1631 support as if it were a basis for recall. They simply said the governor had spent some time, he had been occupied by 1631. It was in the nature of what he was doing when he wasn't attending to this discretionary duty of dealing with homelessness problems. That should not have been included in the recall in the governor's opinion, because it goes beyond the statement of charges. Now, Mr. West has gone forward and tried to support it further in some of his later charges, and what it shows there is that there's a de minimis use that's happening here of the governor's office to support him, exactly as contemplated by RCW 4252-180. We've cited those two statutes in the opening brief. Those statutes concern how an elected official can support an initiative. And the standard there is there has to be no actual measurable expenditure of public funds. That's in subsection B. And the other one says it allows de minimis use of public facilities by statewide elected officials. There's no line that says that the official cannot put his heart and soul into supporting an initiative, particularly when the initiative is something that the governor believes is very important to the state. So in that case, there's no violation of the law shown, or in the alternative, it's certainly not a situation that meets the more intense standard for a recall where there has to be an intent to violate the law shown by the governor. And there's no indication in these anecdotal indications that there was a state patrol officer in the governor's presence when he was collecting signatures, or that the governor went to a meeting to speak, and he mentioned it was on his agenda to speak with a multi-tribal governmental group, and he mentioned 1631. None of those amount to an expenditure of public funds or anything more than a de minimis use of the state facilities as contemplated by law. So we would ask the court to determine that the charges are all legally insufficient and factually insufficient for purposes of a recall, and that the ballot synopsis that the Attorney General's office be approved, but without number 5. And I have an order drafted to that regard that I've presented to Mr. West also.
Thank you, Mr. Geck. Mr. West, you get the last word. First question to you is, which of the, and I'm going to show my hand right now and indicate I'm going to be concluding that the ballot synopsis is prepared originally by the Attorney General's office was sufficient and we're operating off of that. And so I'm making that clear at this point. And looking at these, which of these 5 do you consider to be claims that the governor was acting unlawfully? There's different categories, as you know, of recall charges. The ones where he is alleged to have acted unlawfully, for example, number 5, I think we can all agree is a claim that he acted unlawfully. There is an additional element that he needs to be shown to have intended to act unlawfully. And so for the purposes of my analysis, which ones beyond number 5 do you believe fall in the unlawfully category?
The charge involving well, first off, Your Honor, not to antagonize the court, I don't believe the charges prepared by the Attorney General are sufficient, and I proposed 7 corrected charges. I think it's within the court's discretion to correct the charges. I would ask that the court do so at this time. That I don't think the charges made by the Attorney General accurately reflect the actual original charges, and I believe it's the original charges sufficiency that the court is supposed to rely upon. And the original charges, I believe the portion involving the lateraling of the executive authority to the Secretary of State in violation of the express terms of law, I think that's unlawful. And I think the intent to violate that law is shown in the communications themselves. There's knowledge of the law, and then a communication that transgresses the imperative shall of the law. The governor apparently did not coordinate with the lieutenant governor to ensure that the lieutenant governor would fulfill his duties when he was out of state. Now, when there's an emergency, when they're incapacitated, the succession of office does fall to the Secretary of State, but that requires the incapacity of the governor and the lieutenant governor. And that's exactly what the petition is alleging. They create a condition where both the governor and the lieutenant governor were incapacitated. The office was vacant and the constitutional succession had to kick in. I think that is the essence of the charge, of that charge. The unlawful, per se unlawful activity in was manifest again, I think, in the campaigning. The original charges expressly, at the portion cited, speak to the unlawful use of the office to campaign and promote an initiative, and that constituted a dereliction, a violation of the oath of office, misfeasance and malfeasance. I think that was specifically referred to. I agree that the claims of residing in Olympia are not particularly strong, but I do believe that the campaigning, the lateraling of the office, and the failure to apply the executive powers to deal with what everyone in the state recognizes is a regional public health and safety emergency. You don't have to do anything but drive through downtown Olympia to see we are living in a city that has a public health and safety crisis. I think if you read the Martinez case, if you read the Governor Riley case especially, the intent of vesting the duty to see that the laws are faithfully executed in the executive is to ensure that when, for whatever reason, lack of finances, lack of political willpower, lack of capacity, local government is unable to deal with a crisis, is unable to enforce basic laws like nuisance laws, public sanitation, environmental laws, the executive prerogative powers of the governor are required to step in and remedy the situation. That's why we have executive prerogative powers dating back to the kings of England. If the king of England 8 centuries ago was required to act upon petition of the barons, why is not our president today in a republic required to act on the petition of 18 cities of the state of Washington? Thank you very much, Your Honor.
Thank you. The court is prepared to rule at this time. So these are exceedingly important cases. The citizens' right to hold their elected officials accountable, not just through elections at the conclusion of their terms, but by, as the Constitution recognizes, in the appropriate circumstances, bringing recall petitions is very important to our democracy and our state. These types of cases, the superior courts serve as gatekeepers to make sure that only properly supported allegations and charges move forward to the signature gathering stage of a recall petition. And there are many instances where these types of cases do move forward. I myself presided over one concerning campaign finance issues and the use of public resources with the mayor of Shelton, and I allowed that one to move forward. Every case, however, must stand or fall on its own merits. And so I'm going to be assessing these inquiries item by item. As I indicated before, I do have discretion and I can change the synopsis that is originally prepared by the Attorney General's office based on the charges provided. As I said before, I am not going to be doing that in this case I am exercising my discretion simply to ratify that synopsis as originally drafted. I believe it was appropriate given what the Attorney General's office had and given the posture of this case currently. I'll also note at the outset the standard is that articulated by the Constitution and under associated laws, including case law. It is not whether or not anyone thinks the governor is doing a good job or would want the governor to continue in office in any loose sense of the word. It's whether or not the specific standards that are required to support a recall petition have been satisfied. In this case, we have concerns raised about the campaigning for an initiative, vacancies out of state, where it's referenced that he may be more concerned about running for a different office than the one he currently has, and the concern about the crisis of homelessness that we are dealing with in this community and others. I am not here to say whether or not one side or the other on any of those issues is in the right or in the wrong, but rather whether those issues, and more specifically the governor's conduct with respect to those issues and his knowledge and intent, adequately is supported through evidence in this petition to support a recall petition. So at the outset, I'll start actually with number 2, the residence issue. Mr. West candidly recognized that this isn't the strongest of the charges and that he wouldn't object to this being removed. We are going to be doing that in this case. That claim is both legally and factually insufficient, and I'm not going to go on at any length because of Mr. West's statements about that charge. So turning next to number 1, this is that the governor abdicated his duties and created a vacancy by being so absent from the state. And I'll also view that as including the allegation that he improperly skipped the lieutenant governor, let's say, in delegating his responsibilities to Secretary of State Wyman. I find that this does not state a violation of the law, and further that if it did, it does not is not adequately supported by evidence that the governor intended to violate the law. Based on my reading of the law, the only shall that is required for the governor in these circumstances is that he shall notify the lieutenant governor, and there's no indication that he didn't notify the lieutenant governor. The rest of that statutory provision references what will happen, which is a self-executing provision that the governor may or may not be in a position to make happen. But when viewed in connection with the constitutional succession of powers, it is clear to this court that the governor acted appropriately with respect to notifications in those circumstances. Additionally, with respect to the vacancy in the office, it is not clear to this court that the governor acted in such a way that improperly created a vacancy in the office. And I'll specifically note that to adequately support a recall petition, the charge must define substantial conduct that clearly amounts to misfeasance, malfeasance, or a violation of the oath of office. Given the case law and the legal standards that apply with respect to this issue, I cannot say that that standard has been met. In fact, I can say that it has not been met. And so number one is legally and factually insufficient. I'm going to address numbers 3 and 4 together because they raise similar issues, both factually and with respect to what analysis I must engage in to determine whether or not they are appropriate for a recall petition. Those are the two that concern the issue of homelessness. And I want to pause here to again emphasize that you would have to be blind to not see that we have a crisis concerning homelessness in our community and our region. And I don't think that anyone can or would deny that. But that's not the inquiry here, because one can have a crisis without necessarily deeming it appropriate to declare an emergency or execute certain other powers to address that issue. Much more so, the standard for me in this case, given that these are discretionary acts that the governor is alleged to not have engaged in, is whether or not Mr. West has provided evidence supporting that the allegation that it is a manifest abuse of discretion to not do what Mr. West has pointed to. Given that both 3 and 4 deal with discretionary acts by an elected official, as well as the fact that the standard for those types of acts is so high, I am finding that those charges 3 and 4 are both legally and factually insufficient to support a recall petition. That leaves number 5, the improper use of state resources for the initiative last year. I do not view the law as Mr. West has indicated, that the governor must remain neutral, or any elected official must remain neutral. But the law is quite clear that you cannot use public resources for these types of circumstances. The law does allow certain scheduling things to occur, but there's a very fine line, as we saw from the materials Mr. West provided in connection to the circumstance in Seattle that occurred before. Certain de minimis use of state resources are also allowed. I'm not going to step into, because I don't need to in this posture, whether or not there was an actual violation of campaign finance law, because this is one of the unlawful allegations. Mr. West is also required to support that the governor intended to violate the law in these circumstances. And Mr. West needs to demonstrate that he has personal knowledge, which is not necessarily firsthand knowledge, but some basis for a claim that the governor intended to violate campaign finance laws in pursuing his support for the initiative last year. And I am finding that there is no indication that he intended to violate any laws. I say that without reaching the underlying issue of whether he did or did not, because I don't need to reach that issue given that I'm finding the lack of intent. Given that I'm finding that there is no intent here and I'm deciding it on factual bases, I'm not going to reach the legal insufficiency because again, it needs to be both factually and legally sufficient for me to allow the ballot initiative to move forward. That addresses all of the charges in this case, and thus I am finding that the recall petition overall is insufficient, and it is my decision that it should not move forward. That will require some slight alterations, I believe, to the order that Mr. Geck had provided, so I'll allow him some time to revise that and show that to Mr. West. The parties require any clarification concerning my ruling.
No, Your Honor.
No, Your Honor.
Thank you very much.
Thank
And so
you.
I'm going to allow you to go to the side or somewhere to confer about the form, and we have Mr. Rolfs at this time. And so, and we can hand this back so they can change.
Thank you, Your Honor.
Thank you.